I'm going to talk about speaking with insurance adjusters after auto accidents. I'm going to tell you when it's okay to speak with them, when it's not okay to speak with them, how it can affect a settlement, and I'm going to give real examples of how speaking with adjusters has affected personal injury settlements. Watch the entire video so you don't miss a thing. JZ Helps of Florida Injury Law Firm. I'm personal injury attorney Justin Ziegler. After an auto accident, you need to understand that there are two different types of insurance adjusters. When I say auto accident, I'm referring to car accident, motor vehicle accidents, all of them, motorcycle accidents, truck accidents. The two different type of insurance adjusters are, one, what we call first-party insurance adjusters. That's generally, if you own a car, your own auto insurance adjuster from your insurance company. If you're a passenger in someone's car, and let's say you have a resident relative you live with and you don't own a car, you're that insurance company. And then we have what's called a third-party insurance adjuster, who is the careless driver's insurance adjuster, particularly when you're making a bodily injury liability claim against that careless driver when they did something wrong. The differences between these two different types of adjusters is huge. So first, I'm going to talk about what's called a first-party adjuster. Again, your own insurance adjuster, or if you're seeking first-party insurance benefits. In Florida, for example, there's what's called personal injury protection insurance. That's no-fault insurance that pays up to $10,000 in many cases, regardless of fault in the accident, even if you're driving a car and you're at fault. For every type of insurance adjuster, do not mistake friendly for paying your claim. Many adjusters, in fact, I'd say most adjusters are nice. But just because they're nice, don't be shocked if the facts warrant it, if several months into it, the adjuster denies insurance coverage, denies the claim, pays you nothing, or gives you a low offer. Back to what's called personal injury protection insurance in Florida, also known as PIP. In Florida, you are required to give a PIP statement, a statement to the insurance company about your injuries, how the accident happened, who you live with, etc. Now, the reality is many insurance companies, auto insurance companies, don't ask for that recorded statement or even an informal statement. All things equal, the better companies, generally the national insurance companies that write policies in every state, are less likely to ask you for your statement. That's the good news, and that's just one of the reasons why sometimes when you pay more for car insurance on the front end, when it comes to claim time, the process is easier. They require less paperwork or less statements. Some of the poorer, and by poor I mean poor at paying claims, insurance companies will even require that you drive all the way to their office. Sometimes it's very inconvenient to take your statement. So that's one of the negatives, one of the many negatives of trying to save money on auto insurance. But PIP insurance, who's generally going to be if you have your own car and you're trying to get your medical bills paid or some of your lost wages paid, or if you don't own a car but you live with a relative who has a car and you're going through their PIP insurance, or if you were just a passenger in a car and you don't own your own car and you don't live with any relatives who have PIP and you're making a PIP claim through the host vehicle that you're in all those situations in Florida, you have to give a recorded statement if the insurance company asks. Now, after an accident, many times people are emotional. You're excited, for lack of a better word, or you're nervous, and we tend to talk a lot when we're nervous, and giving a lot of information to the insurance adjuster, even if they don't ask for it, is just a waste of time, but also it can later be used against you in your claim. Only answer the questions asked. Also, for PIP claims, if the auto insurer requires that you complete a written form, which goes over how the accident happened, your injuries, who you live with, etc., what cars you own, unfortunately, in Florida, you have to do it. Some of the worst insurance companies have huge long forms, which are just out of control. The better ones may not are likely to not even ask you to complete the form, and if they do, it's a very short form. The other type of first-party insurance is what's called uninsured motorist insurance or underinsured motorist insurance. Both of these insurances cover you if the careless driver who caused the accident doesn't have enough insurance to pay for your bodily injury. Bodily injury is your lost wages, your out-of-pocket medical bills, and pain and suffering. In Florida, you have to, if they ask, give a recorded statement or a statement to the uninsured motorist insurer. So that includes if you have uninsured motorist insurance through your own car that you own, you have to give it. If you're a passenger in someone's car and you're making an uninsured motorist insurance claim through their insurance, you have to give this recorded statement. And the same is true for giving them an authorization to get all of your medical records and bills. You have to sign an authorization. They are not entitled to your mental health records unless you're making a mental health claim, but you have to comply with these different things. Now, the uninsured motorist adjuster also is not your friend. While an uninsured motorist car insurance adjuster has a duty to act in good faith, their job is to save their insurance company money if they can. So take what they tell you with a grain of salt. If you don't know the answer to any question that either the PIP insurance adjuster or the uninsured motorist car insurance adjuster or auto insurance adjuster asks you, don't guess. This isn't the time to show the adjuster how smart you are. Every single word that you say is either going to be recorded or the adjuster's taking notes, and these can be used against you later on. Again, no matter how friendly the adjuster seems. I'm going to give you an example of an auto insurance accident case where an insured has to give a PIP and uninsured motorist insurance statement. This is the car from a car crash that my client was standing outside. Another car hit him. It fractured the large bone in his lower leg. He ultimately had surgery. Now, he was renting the car, but he was from out of the country. He was renting the car, and when you rent a car in Florida, it comes with PIP insurance. So he had to give a PIP statement. Now, the PIP insurer was a good one, and they didn't require one. Also, his medical bills were very large. He had surgery, emergency surgery done. Generally, a lot of times when that happens, the auto insurer won't request a statement if your medical bills are very high and surpass the $10,000 standard PIP in Florida. The car that hit him had $100,000 of bodily injury liability insurance. It also was a rental car, and they were at fault for the accident for careless driving. The driver that hit my client was working for the United States, so there's essentially unlimited money to recover from if you can prove your case. My client had uninsured motorist insurance through the car that he rented. He opted for this coverage. Under Florida law, like I said earlier, the uninsured motorist adjuster is allowed to and can force the pedestrian, my client, to give a recorded statement. Now, it happened to be of one of the better auto insurers. It was Ace American Auto Insurance. They did not require that my client give a statement, but they could have. In this case, we settled the entire case for $325,000. The uninsured motorist insurance company that my client had purchased uninsured motorist insurance through with on the rental car paid $100,000 of that $325,000 settlement, but you got to be very careful speaking with these uninsured motorist insurance adjusters. They do this for a living, 40 hours a week, if not more. They're very seasoned. After handling thousands of claims or hundreds of claims, they know exactly what questions to ask, and one wrong answer can blow a case. Earlier on, I talked about the two different types of insurance adjusters. We're going to talk about third-party insurance adjusters. These are the insurance adjusters, also known as bodily injury liability insurance adjusters, for the careless driver or the owner of the car that the careless driver was driving. They insure it. Oftentimes after an accident, many people do not want to go through their own auto insurance. They want to make a claim through the other driver's auto insurance, or if they're injured and they don't have uninsured motorist insurance, they directly make a claim against the other driver's bodily injury liability insurance. It is very common, I see it often, where people who are injured give a statement to the third-party driver's insurance company. You do not have to give this statement. Unlike first-party insurance coverage, you have zero obligation to give a statement. I believe it only hurts your case. Many people want to give the statement because they think they're going to get a rental car sooner, and sometimes it may result in that, but oftentimes the third-party insurer, particularly in like a rear-end accident, if their insured admits fault to them, they have enough to know that they are able to pay your case, your rental car, if you need one to get your car fixed, etc. Some people think that you have to give a statement to a third-party adjuster in order for them to pay your property damage to your vehicle. They cannot force you legally to give a statement. You do not have a duty, unlike first-party insurance. In first-party insurance, like PIP or uninsured motorists that I mentioned, if you fail to give a statement, they can argue that you failed to cooperate, and that can blow the coverage, and you can lose out on a lot of money. Third party, you can't blow coverage by failing to give a statement. There's a chance it delays your claim if you don't give a statement and they need one, but oftentimes you don't have to give a statement. Injured auto accident victims also think that giving a quick statement to the third-party insurance adjuster is going to get them to quickly pay your out-of-pocket medical bills, your lost wages and pain and suffering. The reality is, in Florida, in most cases, the third-party bodily injury liability adjuster pays one check to settle your case. I've had one case out of all the cases that I can remember where the third-party careless driver's insurance advanced some money to pay for my client's lost wages, but it rarely happens. So I advise my clients, or most of the time, we do not give a recorded statement to the third party's insurance company, and we rarely give a third party even an unrecorded statement. We rarely give. This is a truck that hit a motorcyclist who was riding on the street. The motorcyclist was riding straight. The truck made a left-hand turn in front of him. He ultimately had surgery to the top of his big bone beneath the knee, known as the tibial plateau. He fractured it. He also fractured his finger and had surgery. In that case, the truck driver's insurance company wanted to take my client's statement, and I told them no, I wouldn't give them a recorded statement or an unrecorded statement. That case ultimately settled for $445,000, but the moral of that story is we received a fair settlement, $445,000, and my client did not have to give a statement to the truck driver's insurer. Before giving a statement to the third-party careless driver's insurer, I suggest knowing which cars are insured and the limits of each insurance coverage. You need to know who your target defendants will be, who ultimately you would like to pay the case so you can build your strategy up against them. And some people get injured in an accident, particularly where there's multiple vehicles involved, and they start placing blame on certain vehicles. There's a chance that one of those vehicles has no bodily injury insurance because it's not required in Florida and most personal private cars, or has very little bodily injury insurance, and then all blame is placed on one driver who only has $10,000 of bodily injury liability insurance, or zero, when in fact the driver who was mostly at fault, even though you don't think so, has, let's say, a $100,000 policy and you're badly injured. I hope you enjoyed the video. Please let me know if you have any comments about speaking with auto insurance adjusters after an accident. Subscribe to our channel, like the video. Have a beautiful day. I'm attorney Justin Ziegler with my office in Miami, serving Florida.